Let's call the case of the People versus Ashton Gregory.
Allie said on behalf of the people, Your Honor.
Good morning, I'm Robert Gill on behalf of Mr. Ashton Gregory. Would you state your name for record?
Good morning, sir. I'm Ashton Christian Gregory.
All right, thank you.
Judge, today's time and date for preliminary exam in this matter. I had a chance to speak with my client. We're ready to proceed.
And Your Honor, at this time, the people are unable to proceed as to count one. I would ask the court to remand counts 2 through 4.
Your Honor, I explained to my client what that procedure is, that we will handle counts 2, 3, and 4 in district court.
All right. Count 1 is dismissed with the people being unable to proceed. This case will be remanded to 14A2 on counts 2, 3, and 4. I'll set a pretrial on that for
March 13th at 11 a.m.
All right, count 1 gets tossed out. That's a big early twist. When a charge is dropped because the prosecution can't proceed, it often means missing evidence or an unprepared witness. But don't get too excited. The remaining counts are still very much alive.
March 13, 2025, 11 a.m. before Judge Barr.
Judge, can we address bond?
You may.
I'm not, is the bond in this matter $25,000?
I had his bond at 5, but what do you have it? It might have changed. Did it change because of a violation? January 25th.
I have an extra on this bond was denied for the other case for a violation.
I have it, yes. I have his bond. I see the new arraignment. I have his bond is denied at this point on this case. Because of...
Notice how the judge keeps circling back to violations? That's legal speak for the defendant breaking bond conditions. A huge red flag. Once a judge hears the word violation, the odds of a bond reduction just plummet.
Okay. Because of a conditional police violation on February.
Judge, would you reconsider a $10,000 10% bond in this matter, Your Honor? I explained to you before, he is subject to epileptic attacks in this matter, and I understand that jail, not denigrating the jail staff or the medical unit, but and he can live with his mom, and I would ask if the court would just consider, please, giving him a $10,000 10% bond. Excuse me.
Sorry. We'd be able to be heard on bond as well, Your Honor.
Yes.
We would be asking that his bond remain as is until sentencing. This case, the defendant has been going on with for some time. He failed to appear back in November of 2024 and had been violating before he failed to appear. He came back, failed to appear to one hearing, but showed up later in the the warrant was recalled. Then he picks up a new case with the same victim, and in that case, there are clear pictures of scratch marks on her as well.
And there it is, a new case, same victim. This detail is devastating for the defense. When a pattern like this appears, the judge's leniency evaporates. Multiple violations plus contact with the victim, that's bond denied territory.
Bite marks, which has also been previously alleged that he's past. I would also be concerned because he has made 42 calls to this victim since his arraignment on 114, and I have great concern that he cannot follow his conditions of bond,
You can look ahead this way.
and that he would continue to contact her. I have great concerns that he cannot follow the court orders.
Well, anything else?
Judge, he may have made some mistakes. I've had a long talk with this young man. He realizes he cannot contact the victim. If he would just set a reasonable bond, I believe he could abide by the bond conditions.
And I believe in the report for his new case he picked up, he admitted to officers that he had been with the victim since arraignment on this case.
Problem is, when I look back, he had at some point posted bond and then didn't appear. He tell me all that. I don't mind giving somebody a chance to do things, but he wasn't following community corrections orders in this case, and it has gone on for a period of time, and then he gets back, and he violating his conditional bonds time and time again. So it's like whatever's said, he just violates the conditions in various ways or doesn't show.
Would you consider a tether, Your Honor?
That doesn't help with the contact.
I understand. I did have a long contact. I did have a long talk with him. He realized he cannot talk to the victim, Your Honor. I think he's been in jail long enough to know that if he does, he'll be here.
Except that the problem that happens is, even in having him in custody, hoping that he'll figure it out, he's contacting can't have it his way. He's gotta, he just can't keep doing it his own way.
Some of the contacts were under his own PIN to her number in the police report, and some were other inmates' PINs.
Just needs to cut it out, play by the rules, and then there's not going to be an issue. But he continues to just want to do things his own way. Most for bond reduction is denied. Bond will.
And that's the gavel drop. The judge has had enough. Repeated violations, ignored warnings, and direct contact with the victim seal the deal. This is a textbook example of how not to handle pretrial release. Play by the rules or stay behind bars.
So Judge,
Or Judge Barr.
Judge, so there's just no bond? Is his bond denied?
His bond is denied.
No, I just asking to clarify.
Yeah, no, his bond is denied because he's just not doing anything we ask him to do.
All right, thank you, Your Honor.